The Indian military has been in a state of churn like the country at many different levels. Other than the most obvious transformations of the armed forces into future-ready combat arms, there's a great deal of churn and flux internally too, in the connective tissue of the forces, the laws that govern them and how they operate in a new India. Our guest today, a former Judge Advocate General of the Indian Army and currently Executive Vice President of the Indian Society of International Law, is one of the most respected and well-regarded voices on the subject and the fascinating intersection of legal and military issues both within India and across the rest of the world. He's the author of several most respected books on military law, Major General Nilendra Kumar. Welcome, sir, and thank you so much, first of all, for speaking to India today on an issue that deserves far greater attention in our view than it perhaps gets. And you've been someone who's devoted your entire life to this in the army and post your retirement. So there's a great deal of subject matter to cover. I'd like to start with some of the most visible aspects concerning the Indian military and things that you've been writing about and speaking about. I'd like to start, General Kumar, with the issue of the AgniVeer scheme. And
at the outset,
much has been said about it.
Yes.
And I want to know what your view is.
Thanks, Shiv, to start with. Now, you have raised a very pertinent issue relating to AgniVeer, because that is the soldiers at the induction and cutting edge level. Now, there are certain very obvious flaws with this system. The basic is that a soldier, when he is selected, it's a matter of pride for him. And it gives him enormous satisfaction and confidence that for the tenure of his service, he would serve with loyalty, discipline, and earn respect. Now, this thing would stands challenged in the AgniVeer, firstly because the tenure is restricted. So, therefore, it injects an element of uncertainty. What's going to happen? He doesn't know. His confidence level is impacted, and he also becomes nervous and confused. Now, supposing I am the commanding officer and I get to receive the AgniVeer, the difficulty is that in the erstwhile scheme, which was followed for decades and centuries, all these soldiers, combatants, they went through the basic soldiering, followed by their trade work. To illustrate, in artillery, after the initial training, a person would get training as a gunner or as an operator or as a driver or as a surveyor, whatever, and likewise in Armored Corps, mechanized infantry, elsewhere. Now, what's happening in the new scheme that's connected to AgniVeer is that there is initial training for 6 months at the regimental center, and then he comes at the unit. Unit may be in a peace station, it may be in a field, it may be in a hard field, it may even be in the glacier, etc. It is expected that the trade work would be taught to him there. Now, this suffers from certain inherent problems. To illustrate, the unit does not have that trained and experienced instructors to train that. They do not have time, because everyone in the unit is assigned his primary job. There are no trainers or teachers for that. They do not have equipment. And this AgniVeer himself would be part of, say, in artillery, of a battery or a troop or a gun detachment. So he has to work there. So with the result that he comes to a unit when he is not fit or he is unfit or a misfit in that setup. Apart from that, it brings in an element, I spoke about uncertainty. All this while for next 4 years, he is worried as to what's going to be his future. Whether he is going to be retained in the army or he would come out. Now, this would give him sleepless nights. What happens during these 4 years if he gets married or he has children? He would suddenly, as a married person, become unemployed without a job.
Yeah.
There is no job assured to him. Now, it is these elements coupled with a lack of clarity as to how an officer is going to judge that out of 4 AgniVeer in his platoon or in company, 3 are going to be selected.
Right.
1 is going to be selected and 3 are going to be rejected.
What would you prescribe should be the formula in that case? I know that's a big question because the intention of the AgniVeer scheme, as it has been communicated,
Perhaps
is to optimize, create a leaner force, a younger force, etc.
I think this argument about a leaner force has got nothing to do with this. Perhaps it was clearly understood that the intention was to cut down the pension budget. Now, in cutting down that pension budget, this method, which has been resorted to, perhaps does more harm than benefit this service.
Right.
And there have been other consequences, like I mentioned that the unit may be in field, difficult field. We heard of a case a few months back where a soldier was immediately sent to Sichuan Glacier.
Yes.
And within a couple of days, due to high altitude effect, he died. There have been other cases also. Now, there is no clear-cut rules whether such soldiers would be treated and would be entitled to all the service benefits that were there in case he was a regular combatant in the erstwhile scheme.
Indeed.
Yes.
Okay. Because this is an issue that's come up politically also, and I imagine it's going to be a big conversation point during this election also. I want to come to the next topic I'd like your views on, General, which is on the issue of Kashmir, the Article 370 abrogation. There are many attendant issues as far as AFSPA, etc. concerned, which I'll come to later. But I wanted to get your view on the abrogation of Article 370 and what has followed, because it seems like indicators and data coming out from Kashmir suggest that things are dramatically improved since the abrogation of Article 370. Tourism is flourishing there compared to how it was previously. Terrorism is down, encounters are down. These are all sort of quantifiable indicators. Your view on that, because there are many connected legal issues as far as that is concerned as well.
Insofar as these non-legal issues are concerned, whether the tourism, the graph has gone up, there are more tourists, and I won't sort of comment on that for the lack of credible data. However, insofar as discipline and law, legal, military law is concerned, 370 abrogation has no direct connection.
Okay.
Nevertheless, you mentioned about AFSPA. Now, this, in light of the judgments of Justice Madan Lokur when he was in the Supreme Court, they create a very important, challenging situation for the military and also the political leadership. Now, my difficulty as I see it is that the problems relating to Special Powers Act have really not been thought of. I'll tell you, I'll just flag few issues.
Yes.
For example, each law, almost all laws, give rule-making powers to the competent government concerned, whether union or the state. This is the only law which does not have rule-making powers. With the result, there is a lack of clarity, specific intelligence or the norms for the officers as to how would the warning be given before opening fire. That's one thing.
Right.
Because the critics have said that it gives unbridled powers to the military to cause death, use force even to the extent of causing death.
Right.
In what language would this be given? Now, I have been suggesting when I was in service, it's been now a couple of decades, that why can't a magistrate be asked, a civil officer be asked to accompany any military contingent going for cordon and search or operation? If he comes, fine. If he doesn't come, at least you have given an opportunity for the state government to send a civil officer.
Right.
why can't the entire operation be videographed? Why can't a confession, if being given by a person who's suspected and has been taken into custody, be videographed?
Right.
Right. What would be the duration of warning? Now, all these are issues that have not been taken. And even when we had the committee that was set up by the Supreme Court, by the central government under a judge, and where we had even Mr. Varghese as a member, they have not applied their mind to such situations. So there is a time now that effective and credible steps be taken to show that the act is being humanized. Otherwise, it would create problems.
Okay, so it's still an unfolding debate that we're having, but those inputs are very, very interesting the way you mentioned them, especially since you've done work in that area, especially General Kumar. From Kashmir, I'd like to get your views now on an issue that is very much live, which is Manipur, sir.
Yes.
Manipur is another issue that has stayed in the headlines in a very tragic manner since last year. We continue to see what's happening there as well. Your perspective on, on the military's involvement in Manipur, this entire situation which came actually from a court, a court ruling had triggered this entire situation. And it is the military that, serves in Manipur and does most of the security work there. Your view on how it is unfolded.
Insofar as legality of the Armed Forces Special Powers Act is concerned, we had Justice J.S. Verma led 5 benches of the Supreme Court their decision, and they without hesitation, unanimously upheld the legality.
Yes.
But then there were certain caveats that were issued by the 5 judges bench. For example, they had said that a declaration about an area being a disturbed area and invocation of AFSPA can't be uncertain and unlimited.
Right.
It should have a shelf life of 6 months. After 6 months, a fresh notification is needed, whether to retain in the entire that geographical entity or to cut it down, remove some districts or whatever.
Right.
That is not happening. They had also given the army authority to interrogate and authority to take those weapons, etc., that have been captured.
Yes.
Now, despite that, the military, I'm sorry to say, has not amended its battle procedures, SOPs, to introduce these things. So there is a need that the act should be humanized.
Right.
Insofar as Manipur is concerned, it appeared during the Manorma Devi, that famous case, that the agitation was more against Assam Rifles than against the military.
Right.
And at a certain stage, the state government said, okay, withdraw AFSPA. Now, that was a very good testing occasion.
Yeah.
It gave an opportunity to the union government and also the MOD to say that, okay, try it out. If you can function properly, then it is good. But as soon as the situation there, the fight between those ethnic groups in Manipur had started, perhaps an opportunity had come to take prompt remedial measures. I don't think that have been done, because had the army been used there in aid of civil authorities, that is the civil administration, perhaps this climate there would not have aggravated to a situation that it did.
Right.
And therefore, to restore the confidence of the people, I think it was time that the men in uniform, olive green, should have been sent there.
What would you prescribe the military needs to do right away, sir, that they haven't done in Manipur as far as these issues are concerned?
Manipur, you see, somehow...
Because it's been going on for more than a year now.
Yes, quite right. You see, military in that disturbed area where they have been injected, they need to be given an authority to restore peace and tranquility, and to show their authority that, look, no nonsense would be tolerated, any illegal, unlawful activity will not be accepted.
Right.
Perhaps that is not happening. there is still interference by the political elements.
Right. I'd like to sort of zoom out now from Manipur, General, with your permission, and talk about a subject that you're considered actually a global expert on. You've written books on it, on international humanitarian law. I want your perspective on where India is at as far as international humanitarian law is concerned. India is one of the largest contributors to UN peacekeeping missions across the world as well. How is that going, sir? Enlighten us on where India stands and what needs to be done.
Now, there's something very dear to my heart.
Yes.
Yes, on the one side, you have brought it out that India is the largest contributor of the UN peacekeeping troops. India was one of the first countries to have ratified Geneva Conventions. Yeah. And thirdly, India, way back in 1960, brought Geneva Conventions into the domestic law by enacting Geneva Conventions Act. However, after that, disregarding the situation that having won our independence through peaceful means, right from 47, India has been engaged, has been brought into armed conflicts with Pakistan, with China, peacekeeping troops. It had to send the troops into Goa, before that Hyderabad, IPKF. So Indian military has been engaged with weapons. Now, I find it very difficult to understand, given this situation, and the fact that it is said that the biggest or an occasion when the largest number of troops were taken as prisoners, more than 90,000, I find it difficult to comprehend as to how there is no literature still in public domain as to how were these prisoners treated.
Right. Very true.
It couldn't have been that none of the 90,000 did not try to escape. There were no cases of manhandling. There is nothing. The historical division of the Ministry of Defense, they also have no data on this. That's one. Therefore, the Army War College, the Infantry School, the Staff College, NDC, they do not have any case studies how to handle prisoners.
Yeah.
What to do, what not to do. There is no reason why, after the Geneva Conventions of 49, the two additional protocols that came in 70 decades, the India chose to keep away from them. There is total silence. There's no debate. There's no parliamentary question. There's no white paper. There is nothing as regards the reason why India decided to keep away. There is no reason why India did not say that, for example, anti-personnel landmine treaty, that we cannot accept this for these reasons, or say till next 20 years when we would have total surveillance by satellite, till then we need these landmines. There was no such decision given. It is total silence or it's all dark.
Yeah.
Moving on, India took a very active part in the PrepCom meetings when International Criminal Court provisions were being drafted. And suddenly it decided to stay back. I had an occasion to share a meeting with Mr. Ram Jethmalani, who had been India's Minister for Law and Justice, and he admitted that he was a cabinet minister and he did not know. In fact, he went to the extent of saying that the issue whether India should join or not join never came before the cabinet.
Wow.
Now, this is something. Now, look at it. When we had the case of Saurabh Kalia, who was ill-treated, or Hemraj, if India had been a member or had been a signatory to the ICC, it could have dragged Pakistan there for those inhuman acts, war crimes. Same situation could have been in the case of Wing Commander Abhinandan.
Yes.
We could not invoke those provisions in the case of Kulbhushan Jadhav, where Kapil Sibal finally had to go in Agu. Now, therefore, by having some underlying fear, India thought that perhaps if we join the additional protocols, Pakistan may drag Kashmir issue and this was an unfounded fear. We did not, ICC we did not, the Torture Convention, anti-personnel landmines, and therefore, apart from these policy decisions at the political level, I have found during my service of almost 3 decades in the military law that with the due seriousness, the subject of international humanitarian law or law of armed conflict is not being taught in the armed forces. It is nobody's baby. The infantry doesn't do it, infantry school doesn't do it, military lawyers, they are busy with their other work, and therefore, when we compare India with regard to the other jurisdictions and the efforts that they have made to bring in the pamphlets, the sort of other presses, handouts, there is an absence with regard to IHL. There's no academy. The language of Geneva Conventions is primarily the Western situation. They still use the word chaplain, whereas we have religious teacher. So after 70 years also, there has been no perceptible seriousness or a concrete effort taken for dissemination, and India could have taken lead. We are going into G20 and we are into...
No, that's what I wanted to ask you.
Yes.
General, that's what I wanted to ask you. With India's rising geopolitical stature and responsibilities, is it too late to do those things, or should that be accorded priority now?
It should be accorded at most. We are a member of the Quad with the Americans and Australian and Japanese. So there is no reason why India does not set up a regional school in international humanitarian law education. And I think with experts, domain experts like you, Shiv, and your channel, these sort of efforts should be demanded, should be focused.
I'm very glad you brought up international humanitarian law, General, because we at India Today take India's global reputation very, very seriously, and we track all things good and bad, and therefore this is something I promise you we will continue to highlight. As we enter the last leg of this very engaging and very illuminating interview for me personally, and of course for all of our viewers around the world watching, I'd like to zoom back into some of the more immediate issues facing the military, sir. We've seen for the last few years an especial focus on the optimization of the armed forces. The buzzword has been jointness for a very long time. The Tri-Services Act has come up for discussion as well. Your view on that and the overall impulse for the military legal framework to get the armed forces to be more synergized. Your view, sir.
I'm happy that you have raised that issue. I find it difficult to understand, comprehend why is this sort of lethargy, if I can use for want of any other word, with insofar as matters of a uniform code of military justice. An impression had existed, which I tried to sort of sort it out, to explain that, well, we have tri-service organizations in the form of training, let NDA or a staff college or the embarkation headquarters or National Cadet Corps, etc. I told them that, look, they are all training establishments. They can do without a Tri-Service Act. But the day we had set up an Andaman Nicobar Command, the day we had set up a Strategic Forces Command, and such like tri-service force structures with the operational responsibilities saddled on them, it was time that we should have had efforts for a Tri-Service Act. Now, this has not happened so far. In the last couple of sessions, Inter-Services Organization Act was brought in. It has major anomalies. Like, say, for example, all three services would continue to exist. This act only would come into operation in relation to a tri-service force. Now, supposing there is a tri-service force and a person moves out from there to a normal Indian Army unit, and then his involvement comes to notice.
Yes.
What would happen? What was the authority of service chiefs? This act that has been passed by the parliament has become a law, having received the presidential assent also. It is silent, it doesn't mention the 3 service chiefs as to what are their powers.
Important, yes.
It talks about Chief of Defence Staff. But what is the role, what is the authority? Because in an act like Army, Navy or Air Force Act, there have to be offences and there have to be authority provided. It does not equip the CDS with any clear authority. It also gives a status, the Service Acts give a status to a soldier at the lowest level by listing out his privileges.
Right,
now this act is silent. So look at the morale of a soldier. He says that this act, and it is the latest act, it is silent as to what are my privileges. For example, when he is going for an operation, he cannot be arrested. He cannot be taken into custody with regard to deficiency in regarding following, comprehending civil legislation. Now the act is silent on that.
Right.
What would happen, the composition of a court-martial when it is dealing with certain accused persons belonging to different uniforms?
Yes.
Army, Navy, Air Force. The act is silent. So therefore it is something that has been hurriedly done without giving due thought, and the time has now come, on one hand, to have a full-fledged, comprehensive, all-embracing code of military justice,
yes,
and simultaneously a review of the defense services regulations. These date back to 1987.
Yes.
Today we are in 2024. They do not have any provision of, say, cyber operations. They do not talk of climate changes. They do not talk about induction of women. And there are glaring shortages, absences in the regulations which were of 1987. They fail to address the demands and issues which a commanding officer at the unit level or an accused as a person facing the music is to contend with. So it is time that these military law provisions are given attention and time.
General Kumar, you've given us a great deal to think about, a lot of food for thought, and I always like ending an interview with the kind of prescription that you have just laid out for us. It's given us something to think about as well, whether or not you track the military. What's happening within the military is very much part of what we consume in the media on literally a daily basis. So, General Kumar, in the hope that this will be the first of many interactions going forward on these issues that require public attention because they are scarcely discussed enough, very grateful to you for giving us your time here on India Today, and thank you for being with us.
Thanks, and I congratulate you for this initiative.
Thank you. Thank you, sir.